Rosenbaum. And whether he was justified in that or not, he's still required to execute his intentions in a way with the minimal, or to minimize the risk to Mr. McGinnis. So and that's a jury determination, I'm not suggesting I would want to be in that position, who would, but he would have to decide, well, I've got to kill this guy, but I've got to do it such a way that I don't hit anybody else. That's really what the jury's being asked to determine. And there are instances that you could imagine where the person actually would have freedom of choice and a conviction could be appropriate. One might not expect that to happen under most self-defense circumstances, but although for an intentional, then he'd be guilty because he intended to kill someone else.
And here's my only argument is, I think the testimony was the bullet that has endangered McGinnis passed through Rosenbaum, right? That Rosenbaum was shot, there's 5 wounds with 4 shots, so he didn't miss. So the reason that I'm kind of hung up on the utter disregard for Rosenbaum is if he would have missed, I suppose, and you could say that shot was a wild shot.
But he was using steel-jacketed ammunition.
Bullets are bullets, Judge.
No. I'm picking at hairs because that's what we lawyers get paid to do. But and of course, if we were in the jury room, and we'd laugh at each other for the things that are being said. But in the eyes of the jury, they could theoretically, like how many angels fit on the head of a pin, they could theoretically think, well, it does make a difference because he wasn't using expanding ammunition. He was using a full metal jacket, and he should have foreseen that it might have gone through and that it would endanger someone else.
And the defendant also denied knowing he was there, so the jury can very...
He did indeed. That was my next point.
My only argument, Judge, was that if he's using utter disregard, or the jury believes there's utter disregard as it relates to Mr. Rosenbaum, the charge as it relates to Mr. McGinnis directly relates to the bullet that went through Mr. Rosenbaum's hand or head or whatever it is, right? So that's why I'm saying if it's that for Rosenbaum, it has to be the same for McGinnis, only because there's not a wild shot. He didn't miss. He wasn't spraying. Nobody's alleged anything like that.
You could say that in your argument, couldn't you? If I left this on their verdict and you had to argue it, you could say.
I certainly could.
Pardon me?
I said I could.
The evidence does show that he essentially missed the 3rd or 4th shot. There's a graze wound that then traveled who knows where, possibly towards Mr. McGinnis. So this is not as though all 4 bullets entered Mr. Rosenbaum. One skipped right by him and basically had a contact wound. And the defendant says he didn't think he was there. So a reasonable jury could find that how do you show utter disregard for Mr. McGinnis when the defendant claims he didn't even know he was there?
I'm going to think about this one. My inclination at this moment, to repeat my former statements that have caused some consternation, my bias would be in favor of submitting that verdict and giving this instruction. But if it shows up on your doorstep, your email doorstep tomorrow at some point, and it isn't in there, don't be terribly surprised. All right. Count 4.
So count 3, it's essentially the same issue, except obviously this time the defendant knew he was there. I'll essentially make my arguments that I believe firing 2 shots, missing, a reasonable jury could find that he was not showing utter disregard. He only fired twice instead of 4 times. He did not fire into the individual after already striking him twice, as he did with Mr. Rosenbaum. He did not continue to fire. So I believe the mere fact that he fired twice and did not hit a reasonable jury, and again, we believe that first degree is the most appropriate charge, but a reasonable jury could find that because he stopped firing, he was not showing utter disregard.
We are talking now about a jumpsuit? Jump kick.
I'm for blue hoodie man.
What do you call him?
Blue hoodie man.
Blue hoodie man?
He becomes jump kick man once he kicks him in the face.
Oh, touched it.
Did you want to respond?
Yeah.
It's the first time I've ever heard that missing someone when you're firing from point blank range means that you're not showing an utter disregard for human life. So he fires Judge, he's on top of him when he kicks him in the face, and you saw the shots. It is difficult to ascertain an argument that a jury would believe because he stopped shooting or missed from point blank range with an AR-15 that he wasn't showing utter disregard for human life. I don't think that's a logical argument. I think the appropriate instruction is 1345. They're either going to accept that it was self-defense in that or they're not. But to say point blank range, 2 shots on a man jumping on you, yeah, that might not show an utter disregard for human life because either he missed or he stopped. I don't buy that as logical, and I would ask that you just give 1345.
If his conduct, the standard for the lesser included, I think, is still there is ground in the evidence for acquittal on the greater and conviction on the lesser. The same set of facts. What's the difference between what you're charging and the lesser?
I've stated what I think the difference is. My worry is that the defense, I've asked now a couple times if they're just going to agree that there's utter disregard, and they have not agreed to do that, is that they're going to get these instructions and then argue it in their closings, and then we are stuck. So I would like some sort of limitation.
Why wouldn't they argue in the closings what the instructions are?
That they will argue that there's not utter disregard. That they will argue the opposite of what they're saying now.
No, I'm not hearing that.
Well, then why not agree to it? If they are agreeing that there's
they'd be nuts. That's why. How would that be?
What's that?
They'd be nuts. Why in the world would they concede an element like that?
Well, they're conceding it right now.
No, they're not. They're discussing it for purposes of whether or not the lesser included should be given. They're saying, they're not conceding all your evidence, they're saying it's hard to believe that this would constitute or not constitute utter disregard for human life. Let me repeat the question I just asked you. I don't think there's a dispute in the evidence as to this individual, Mr. Jump Kick Man. The video is claimed to depict that he kicked the accused in the head. That the accused turned and fired at him twice and missed. On what ground could they convict him of the lesser without having convicted him of the greater?
Well, I'll stand by the prior arguments of the defendant's own statements, and also I think it does make a difference that he shot 4 times at Mr. Rosenbaum after he was already crumpling to the ground. The fatal shot was as he was falling to the ground, and he stopped shooting at the man in the blue hoodie. Again, I think the first degree is the appropriate charge, but I think a reasonable jury can say, why did he stop firing? Why didn't he, fire at him as he went away? I feared he might come back and run at him. So I believe a reasonable jury could find that. And frankly, if the defense in their closing argument tries to quibble with the utter disregard, I don't know if it's precedent for it, but I think we're going to ask for lesser includeds after that, because we're going to ask for lesser includeds after that. if they're admitting here that there's no way a reasonable jury could find otherwise, if they're agreeing to that, that's one thing, but
Well, if they are agreeing to that, then why are you asking for a lesser included?
well, they're not agreeing to it.
But I understand, I actually do understand what you're saying, I think. But let's do it again. Let's talk about the incident involving Jump Kick Man. What he was doing, what the defendant was doing, firing a gun at a human being.
Yes.
He hasn't alleged that he wasn't firing at him. He wasn't saying I was just trying to scare him off with a couple of shots across his bow. He didn't say that. Why he was engaged in it, and he's given his reasons, and I don't think the state disputes them. He was doing it to prevent the man from attacking him, and the state says the man had the right to attack him, and the defense said he didn't. Either way, he was doing it for what he was doing. It was purposeful. How dangerous was the conduct? Well, the defense is not disputing it wasn't dangerous behavior. I don't think they're going to argue that. How obvious was the danger?
The defendant denied that it was obviously dangerous. He said he did not know if it was going to kill him. He did not know that he denied knowing or that his bullets were more dangerous than other types of bullets. He denied knowing that his gun was more powerful than other guns. So again, I think the evidence most.
I don't think that is exactly what was stated. For example, the discussion about what kind of guns are more powerful. That wasn't actually it. I was kind of intrigued about it because it was a close contact, and the suggestion was being made by the questioner, Mr. Binger, that the rifle is because it's a more powerful weapon was more dangerous or something to that effect. And of course, in a close contact situation like that, it may be that the pistol is a much more desirable weapon. But I thought that discussion was focused on that type of issue rather than your claim that the defendant was suggesting his weapon wasn't dangerous? That it wasn't obvious? The danger wasn't obvious?
Judge, in his testimony, the defendant said, essentially, I was in fear for my life, but I didn't mean to kill him.
Is that what he said, or did he, when he was asked, did he mean to kill him, he said, I was just trying to defend my life, or words to that effect?
He said, I did not want to kill them.
Did he? I don't remember. Mr. Binger says yes, Mr. Krause says yes.
He said,
I think that's fair. At some point or another, he did say he didn't want to kill anybody. That's true.
Anybody that night.
But that's not the element. If we're first degree, then that'd be another matter. This is reckless endangerment.
We're talking about the defendant's mind and if he had utter disregard.
No, we're talking about how obvious was the danger.
We agree. The state, under their evidence, has shown utter disregard. What we're fighting about is that it's not.
I'm still struggling with what is the basis upon which the jury could acquit of the greater and convict of the lesser, because that's the standard.
If they believe the defendant, they have a basis for the lesser included. There is a basis. If they accept the defendant's testimony,
I didn't want to kill anyone?
That I didn't want to kill anyone, that he bought the gun because it was cool.
I might even buy into that. I might. Except that would be if we were talking about a charge of count.
4.
Because intending to kill is not an element of this crime.
But it shows whether he utter disregard if he's firing and not considering.
You're getting to the ultimate fact. I'm telling you what the factors are and determining whether there's utter disregard, and you're telling me that one of the factors to be considered on whether it's utter disregard is utter disregard. That doesn't make any sense.
Well, like I said, I believe the defendant's testimony gives a reasonable jury a basis to find a second degree.
I don't. So I will not give that instruction or submit that verdict. And the reason is because I do not feel there is a basis in the evidence for acquittal on the greater and conviction on the lesser. Count 4, number 2. You're asking for 1017, which is you're asking for 3 lessers. First, you're asking for first degree intentional. You're asking for second degree intentional, or first degree reckless, or second degree reckless.
Yes.
So, now give me the bases for acquittal on each of the greater crimes and conviction of the lesser.
Well, with first degree intentional homicide, obviously there's a self-defense. The jury can find imperfect self-defense and find second degree intentional homicide, that if he did not reasonably believe the force, if it was not reasonable for the amount of force used. The defendant, again, while testifying, said he did not mean to kill Mr. Huber. So they could find from that alone that there is not an intent at all and go to the first degree reckless. And then we're left with the argument that we've been having all morning thus far, which is whether a second degree reckless showing utter disregard would be appropriate. The defendant said he didn't mean to kill him. The defendant gave his reasons why he thought he had to shoot him, but again, I believe he indicated he denied that he knew it would kill him, and essentially it's the same argument that's been being made all morning. But I think it's quite clear that in a self-defense case, second degree intentional is appropriate, because the jury could very easily find in this case that it was not perfect self-defense, as a person who is running at him, being told, or perhaps even witnessing himself, that the defendant has already shot someone, gravely injured them, has already shot at another person missing, and then gone in to try and disarm him. The jury could find that it was not perfect self-defense.
Are you disputing that?
No, first and second.
First and second,
No.
Intentional are okay.
Yeah.
Okay. So then the reckless, the defendant testified directly that he did not intend to kill him.
Any dispute as first degree reckless?
No.
Okay. All right, any objection to second degree reckless?
For the exact same reasons that we had talked about, Mr. Huber, I'm sorry, Judge, if you already...
No, that's all right.
Mr. Huber has the evidence was a rifle pointed up against his chest.
I didn't hear you.
He has a rifle, according to the evidence, he has a rifle pointed literally up against his chest. So the idea, under those circumstances, that having an AR-15 pointed buttressing up against your chest would not be utter disregard for human life if believed, to me that's where it begins and ends. There is no other explanation. So I think first degree, second degree lesser included, first degree reckless are all appropriate. Second degree reckless doesn't fit.
Did you want to respond?
I'll just stand on our arguments before. This afternoon, we may review the defendant's testimony, and if I find a specific thing that I think changes it, will obviously contact the parties.
Okay. I embrace the argument of Mr. Shavafsi. And count 5, You are, and that is the shooting of Mr. Grosskreutz, and that is charged as intent to kill?
Correct.
Okay.
So the instruction I requested is attempted first and then attempted second for very much the same reasons as Mr. Huber, that a reasonable jury could find imperfect self-defense, as Mr. Grosskreutz was actually facing away from the defendant when he fired. And then the next lesser included, if they don't find intent, is the first-degree reckless endangerment. So I've requested that, and then obviously I've requested secondary reckless endangerment, which we've rehashed a few times now.
Defense?
Judge, I don't have an objection to the lesser included on the second-degree attempt. It's the same argument. The court heard the evidence. In the distance, Mr. Grosskreutz testified that he was about 3 feet away, whatever it was from him, when he was shot. The gun, Mr. Grosskreutz pointed the gun at the defendant. Mr. Rittenhouse then fired. So I think that first degree, attempted first degree, well, you can't attempt a reckless act, right?
I would have told you, I would have agreed with you some years ago, but I'm not sure. I don't know the answer, and I certainly am going to have to hit the books on that.
Okay.
That was certainly once the law.
I would have, you either are, to me, you're either reckless or you're not reckless. So I would object to any recklessness because I don't think you can attempt a reckless act. So I'll leave it at that and let the court ponder that.
Well, the defendant did testify that he didn't want to kill anyone.
I understand that, but I think somebody would say the behavior is either reckless or it's not. I don't know how you can attempt to be reckless or attempt to be negligent. I don't know how you can do those things.
Judge, if I may respond, I mean, we just basically agreed on the comment by Mr. Huber that reckless homicide was appropriate. Mr. Grosskreutz did not die, so the appropriate charge at this point would be the first-degree recklessly endangering safety. The jury could easily find that the defendant intentionally shot Mr. Grosskreutz, which is not, I guess, in dispute, but that he did not mean to kill him. The defendant said multiple times, "I did not want to kill anyone." The jury could also find that shooting someone in the arm, if they find that was where the defendant was aiming, would not be intent to kill, but it would be recklessly endangering his safety. If the jury does not obviously find that it was perfect self-defense.
Is it a lesser included?
Yes.
Statutorily?
Yes.
Yeah, I think you're right. Because otherwise, why couldn't they convict him of both? But why get into a discussion we don't need to resolve? We'll do it later.
Okay.
I don't know. I'm going to think about this one. I'm inclined to agree with Mr. Krause. Okay.
On count 6, we are not requesting any recklessly endangering safety charges, so we can skip that argument.
Bless your soul. Now, the defense has submitted, and I don't think you submitted anything standard, except standard on that.
Our position is they never raised the affirmative defense. So that's why we didn't do it.
At the trial.
Right.
Let's see.
And obviously they can argue otherwise, but that's why we did not prepare one. Obviously they can argue otherwise, but that's why we did not prepare one.
don't recall any evidence, correct me if I'm wrong, as to the third element of the second defensive matter, which you cite on the second page, on the third page. Item number 3 on the third page. I don't recall that evidence.
I would agree there was no evidence that he...
Then how can I give that instruction? Oh, because they have the burden of proof.
It's not a strict liability offense.
Yeah,
He's 17 years old.
Yeah, if there's an absence in the evidence, that's kind of a problem for you, no?
What do you mean?
You would need to disprove the affirmative defense.
We don't believe it was ever raised. They never gave any evidence as to barrel lengths or that it
Oh yes, there was. There was definitely barrel length evidence.
on cross-examination of a state's witness.
Whenever it happened, it was there.
And
Well,
there was-
now I'm not sure. There was evidence of the length. He had the ruler out and he had measured the length of the portal.
I asked Detective Antranian.
Did you?
Yep.
Assuming that to be true, then that would. Then that was less than. Excuse me. It was the barrel length was greater than 16 inches.
Sorry.
Wait a minute. Either the barrel length was less than 16th or the overall length was less than 26. That was in the evidence?
What I asked him was there any, did he believe, I want to make sure I have it right so I don't misstate it. Did he believe that the barrel length was in violation of the law?
What law? I mean, there may be, I don't know what laws there are.
The possession of a short barrel shotgun or short barrel rifle.
That's the only.
That's the law. You can't have a
You're
gun
talking
that's...
about, okay,
Yeah.
okay.
And that's built into
Okay,
this
well,
instruction.
he certainly, come on, it's not a strange issue in this case. I mean, we've been talking about it for months.
Well, and I agree with talking about it for months, and the defense should have measured the barrel in front of the jury and said the
You
barrel.
have the burden of proof.
That they didn't. If they raise it, they never raised this issue.
Well, did he ask the detective whether it was what was your question as you recall it? And this is going to be dependent upon what the actual evidence was. But what do you claim it was?
When he took the gun from the Antioch Police Department, did he believe that there was a violation of the law as it related to the barrel length?
That goes to his belief in what, and they never specify which law.
They have to raise the issue.
I understand, and I don't believe that they have. And there's no testimony on the authorization, the certificate of accomplishment to obtain authorization for hunting. There's no evidence on whether or not he has a certificate of accomplishment to obtain authorization for hunting, which is the state's position all along, is that he would have to have that.
Well, they're claiming it's in the alternative.
And the state has always claimed that it is not. So we're back at, well, if the court finds they raised it, which I don't believe asking a general question on the belief of a detective, that is not evidence, the belief of someone.
Well, is it a belief or an observation?
The way Attorney Trossi just said it was belief. We'd have to get the exact question, but I don't believe...
The exact question may become important.
So I don't believe that is raising it. And the defense at every opportunity, they brought the gun over here most every day the last few days. They could go to any number of witnesses to measure it and raise this issue, and they did not.
They don't have to measure it. That's the burden of proof it's on the state.
I understand that, but it wasn't raised. Is our
Well, if he asked the officer, and I will have to see what the transcript says, if he asked the detective whether the rifle was compliant or what are you claiming you said?
I asked him if there was, I know I asked him about it. The question I asked, I think I asked him something along the lines of, did you believe there was any violation for the barrel length of the gun?
That would put it in issue if the question is like that.
Well, also the statute reads, this section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of section 941.28. or is not in compliance with the two sections mentioned. So it's an or, it's not an and. We don't have to show all three. So they may have raised the issue with...
You have to show one of the three. You have to show one of the three. No. What am I saying?
No, we have to show...
You have to show any of the three which the defense has put in issue.
So
The defendant has not put in issue the certificate of accomplishment.
Correct.
The defendant has put in issue the length of the barrel.
And Judge, we can unpack this for a minute. So the exception says it's a violation of the law if you're under 18 and possess a short barrel shotgun or rifle. Okay? That's one way you can be convicted. And it says, or are in violation of Wisconsin statute, I think it's 29... 29304. 29304 only applies to people 16 years of age or under.
Right.
There's been testimony that he's 17.
No.
Okay? So I've conceded, because he has to be in violation of both 29304 and 29593. I concede he's in violation of 29593. However, 29304, he's 17. It doesn't apply to him. It can't apply to him because of his age. We put in his age and we put in the barrel. That covers the first exception, and then it goes to or, and it covers the second exception as well. I provided the court, and I'm not rehashing it, that you had denied the motion for reconsideration. This statute doesn't apply to 16 and 17-year-olds, period. The legislative history that I provided to the court, it says it in black and white.
Well, I ruled as I did because the motion to dismiss attacks the complaint.
Understood.
And the complaint was adequately pled under the law. That was not an endorsement of the state's position on the case. And where to use a trade expression, the rubber hits the road here at the trial. So now you have to prove everything that the statute requires. And do you dispute the fact that you need to prove that the defendant was under 18 at the time of the incident? You don't. That's not in dispute.
that he's under 18, yes.
And that the barrel length was less than that allowed by law. Or was not within the range permitted by law.
We don't have to prove that.
You don't have to prove that.
But it's or. I mean, there's no real... Our argument is that they did not raise it. I don't think it's really a disputed fact. But we believe they did not properly raise this first part of the exception. The second part of the exception, they've conceded 29.5...
Go ahead, I'm sorry.
They've conceded the 29.593 portion. He did not have a hunting certificate. So then we go to 29.304, and if it is allowed that simply being 17, he is in compliance with that, it swallows the whole statute, and the statute makes no sense. So if the statute...
If it makes no sense, you're out of luck.
Well, if the statute is valid, it's clear as day that it says a person...
Clear as day. I would not say that about this law.
Well, I would maybe not say that about the exception, but the actual law, 2A, is quite clear.
It is.
Sure. Any person under 18 years of age who possesses or goes armed...
Well, that's not the whole statute. That's not the whole statute.
Our position is that he is not in compliance with 29.304 and 29.593. And I know that this was scoffed at when I mentioned it before, but 16 and 17-year-olds can hunt alone in this state if they have the correct certificate.
Okay.
Under 16 cannot, and that is what 29.304 is addressing. This statute is addressing hunting.
You know, the basic law is that the rubric is not part of the statute.
The rubric?
The title.